New Mexico adopted its own version of the Uniform Owner-Resident Relations Act, and it's found in New Mexico Statutes, Chapter 47, Article 8. If you're a landlord in New Mexico, this is the statute that defines your habitability obligations, and it's more detailed than you might expect for a state in the Southwest. Under New Mexico law, landlords, referred to as owners in the statute, must comply with all applicable building and housing codes materially affecting health and safety. You're required to make all repairs and do whatever is necessary to keep the premises in a fit and habitable condition. That includes maintaining the structural components of the building, keeping plumbing in working order with hot and cold running water, ensuring electrical systems are safe, providing adequate heating and cooling systems, supplying working smoke detectors, maintaining common areas in a clean and safe condition, and providing adequate trash receptacles. One thing that's interesting about New Mexico is the climate factor. With extreme heat in the southern part of the state and genuine cold in the mountainous north, both heating and cooling are habitability concerns depending on where your property is located. A landlord in Albuquerque needs to think about air conditioning just as seriously as a landlord in Santa Fe needs to think about heating. If the unit was leased with cooling or heating systems, maintaining them is your legal responsibility. New Mexico's remedy process follows a notice and repair framework. Tenants must give the landlord written notice of the habitability defect. For issues that don't involve essential services, the landlord gets 7 days to make the repair. For failures involving essential services, like no water, no heat, or no electricity, the timeline is compressed, and the tenant can pursue remedies more quickly. If the landlord fails to repair within the required time frame, New Mexico tenants have several options. They can pursue damages in court for breach of the warranty of habitability. They can seek rent abatement reflecting the reduced value of the unit. They can obtain injunctive relief, meaning a court order forcing the landlord to make the repair. And in cases where the failure involves essential services, the tenant can arrange for the repair and deduct the cost from rent, or procure substitute housing and deduct that cost from rent while the unit is uninhabitable. New Mexico also has a provision that allows tenants to terminate the lease if the landlord's failure to maintain essential services persists. The tenant must follow proper notice procedures, but once those are satisfied, they can walk away without penalty. The state's anti-retaliation protections are solid. Landlords cannot increase rent, decrease services, or file for eviction within 6 months of a tenant making a good faith habitability complaint or exercising their legal rights under the Act. One practical consideration for New Mexico landlords: the state has a significant amount of older housing stock, particularly in historic areas of Santa Fe, Taos, and Albuquerque's Old Town. Older properties often come with unique maintenance challenges, including aging plumbing, outdated electrical systems, and adobe construction that requires specialized care. Understanding these challenges up front helps you stay compliant and avoid expensive surprises. For the complete guide to New Mexico's habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you stay current on every state's requirements.